Good afternoon. Welcome to today's webinar, a civil justice preview of the Supreme Court's 2022-2023 term, sponsored by the Law and Economics Center at George Mason University's Antonin Scalia Law School. This is a fitting way to lead up your Constitution Day celebrations tomorrow, although today we'll be focused on civil justice issues at the court as our principal area of focus. I'm Donald Kochan, and I'm a professor of law at Scalia Law School and also the deputy executive director of the Law and Economics Center here at the school. I'll be moderating today's discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of legal and public policy issues confronting judges and policymakers nationwide. Our commitment is to developing original, high-quality law and economics programming to further this mission and to further enhance economic understanding and provide information that is useful in the legal and public policy debates surrounding these issues. We thank all of you for joining us today to engage in that dialogue. Our panel of experts today come with impressive backgrounds litigating before the U.S. Supreme Court and monitoring developments there. But so that we can reserve time for substantive discussion, I'll only give very short basic introduction of their bios. And I recommend that you go to our website, masonlec.org, or look at the email that you received as part of your invitation and acceptance into this webinar for links to their full bios. Our distinguished panel today includes John Beisner, who's a partner at Skadden, Arps, Slate, Meagher, and Flom, LLP, and Robert Peck, who's the president of the Center for Constitutional Litigation. They're going to go back and forth, highlighting some key cases to watch in the upcoming term and engage in a discussion with each other. And then we're going to open up to all of you for questions and answers. Please use the Q&A, the question and answer box at the bottom of your screen to submit your questions. Please identify yourself and your affiliations so that we can identify you on the program. And please keep your questions at a suitable length that can be actually presented in a webinar. With that, I encourage you to listen in for the next hour. We turn it over to John Beisner to get us started. John. You're muted, John.
Thank you, Donald. I appreciate being with all of you today. Bob, it's also a pleasure to be with you once again to discuss these issues. Well, as Donald noted, our mission here today is to discuss cases that have been accepted for review in the upcoming Supreme Court term that present civil justice or economic issues that potentially have broad ramifications. And as Bob and I were going through the docket, I think we concluded that this upcoming term is not especially rich in such cases, but the court has delivered on one topic that Bob and I have spent time discussing in prior episodes of this seminar and our webinar, and that's the subject of personal jurisdiction. Put simply, this is the issue of cases addressing the question of where a corporation may be sued. The Supreme Court activity on personal jurisdiction in recent years has been more focused on specific personal jurisdiction, that is personal jurisdiction that arises out of or relates to defendant claim related activity or contacts with a particular forum, that is jurisdiction that arises out of facts that are specific to the claim that is being asserted by the plaintiff in the case. But this time around, the question before the court involves the concept of general personal jurisdiction. That is personal jurisdiction that arises out of the defendant being so entrenched in the forum that the forum's courts may hear any or all claims against the defendant. At least that's the traditional view of that issue. And we often refer to this being under precedence as being the notion of a corporation being at home in a particular jurisdiction, and that usually involves being the state of incorporation for the company or the state which is its principal place of business. The question that is before the court this time around is whether the due process clause of the 14th Amendment prohibits a state from requiring a corporation to consent to personal jurisdiction as a condition of doing business in the state. The question arose here in a case that is called Mallory versus Norfolk Southern Railway Company, and it's set to be argued in November. In this case, the petitioner, who at the time of filing his lawsuit was a resident of Virginia, filed suit in Pennsylvania state court for injuries he allegedly sustained as an employee while working in Ohio for Norfolk Southern Railway. And that company is based in Virginia. That's where the company is at home under current standards. The action was brought under the Federal Employees Liability Statute. Now, Norfolk Southern, in this case, moved to dismiss the action upfront for lack of personal jurisdiction, saying it was not at home in Pennsylvania. Now, in so moving, and this is the critical piece of what the court will be considering here, the defendant acknowledged that there is a Pennsylvania statute that requires a company to register with the state before doing business there. And the defendant further observed that the statute contains sort of a warnings clause, if you will. And the statute says that registration, and I'm quoting the statute now, shall constitute a sufficient basis of jurisdiction to enable the tribunals of this state to exercise general personal jurisdiction over such person. I think, and Bob may correct me when he speaks, I think that may be the only state that has that sort of warning provision in the requirement that a company needs to register to do business in the state. Although many states have the requirement that you have to register to do business there. Indeed, I think that's universal among the states. Now, defendant argued that such a statute violated the 14th Amendment's due process clause, and therefore the case that the plaintiff brought should be dismissed. The trial court agreed, and so did the Pennsylvania Supreme Court. So this goes up to the Supreme Court with the defendant having prevailed on these arguments. Both courts observed that consent to general personal jurisdiction provides an independent basis for jurisdiction, but only if that consent is given voluntarily. And as the Pennsylvania Supreme Court put it, a foreign corporation's registration to do business in the Commonwealth does not constitute voluntary consent to general jurisdiction. And it thus held that the Pennsylvania registration statute is unconstitutional to the extent it purports to confer general jurisdiction over foreign corporations that are not at home in Pennsylvania. Now, at first blush, the petitioner's briefing suggests that there's a real debate among the courts on this question, pointing out some state Supreme Court cases that come out the other way and some federal circuit cases going both directions. But Norfolk Southern's briefing, to me anyway, seems to blow a lot of holes in that argumentation by pointing out that the splits halted after the U.S. Supreme Court's decisions in Goodyear Dunlop Tires versus Brown, that's a 2011 decision, and Daimler AG versus Baumann, a 2014 decision. And for reasons I'll explain later, I do want to note that both of those decisions were written by the late Justice Ginsburg. As the Pennsylvania Supreme Court noted, those decisions dramatically altered the general jurisdiction landscape. And after those decisions, according to the Pennsylvania Supreme Court's analysis, a court may assert general jurisdiction over foreign corporations only with when their affiliations with the state are so continuous and systematic as to render them essentially at home there. If Pennsylvania could enforce its statutory consent scheme, and this is the primary argument that the respondent makes, that Norfolk Southern makes, is that every other state could adopt this similar paradigm, and it would render corporations subject to personal jurisdiction in every state, which would fly in the face of Goodyear and Daimler. And the fundamental argument that's made by the respondents here is that the unconstitutional conditions doctrine holds that the government may not deny a benefit to a person because that person exercised a constitutional right, and held that the Pennsylvania scheme and argues the Pennsylvania scheme violates that rule because it impermissibly conditions the privilege of doing business in Pennsylvania upon the surrender of the constitutional right to due process. There's 3 points about this case and in part how it got to the court that I find particularly interesting. First, I'd note that there was a competing cert petition out of the Supreme Court of Georgia in a case that actually preceded the filing of the Mallory petition, which is what the court ultimately granted. In that case, which is called Cooper Tire, the Supreme Court of Georgia came out the opposite way of the Pennsylvania Supreme Court, concluding that the defendant's registration to do business in that case did grant personal jurisdiction, general personal jurisdiction as a defendant. It appears to be perhaps the only or one of very few post-Daimler cases to so hold, but there's an important difference between that case and the case that has been in which cert has been granted. As I noted earlier, the Pennsylvania registration statute has a sort of explicit warning in it to companies that if you register, if you go through this registration process, you are submitting yourself to the personal jurisdiction of the Commonwealth's courts. That is not in the Georgia statute and generally is not in the statutes, registration statutes of other jurisdictions. And therefore, in the Georgia case, to get to a finding of general jurisdiction, there needs to be an implied finding that the consent was given to general personal jurisdiction by registering in the state. So the Pennsylvania case has that additional dimension to it. And interestingly, both sides of those in the Mallory case urged the court that if it was going to grant cert, it do it in their case as opposed to Georgia, because the latter case, the Mallory case, or I'm sorry, the Cooper Tire case posed the antecedent question whether one could infer consent to personal jurisdiction from merely complying with the registration requirement. And if the court decided no on that question, it wouldn't get to the ultimate issue of whether there was voluntary consent by complying with the statute. Mallory, though, really gets to the core issue here, and that is, can the registration statute basically confer general jurisdiction? A second interesting point I would make here is that in this case, I think without invitation, the Solicitor General filed a brief which very strongly supports the position of the defendant. And I note that as being significant because the SG's office in recent months hasn't always followed that path. Here, the SG's office said it had an interest in this case because of the possible ramifications of expanding personal jurisdiction on international defendants. And as I said, it's a very lengthy, strong defense of the Pennsylvania Supreme Court's ruling. And it's again based largely on Goodyear and Daimler cases. Finally, I note that a compelling piece of the argument here, which gets a little lost in the briefing, is the defendant's point in the brief that what does Pennsylvania have to do with this case? The plaintiff was a resident of Virginia when the action was filed, as I mentioned. The defendant, Norfolk Southern, is based in Virginia. The allegedly injurious acts occurred in Ohio. And so the only connection of this dispute to Pennsylvania is that Norfolk Southern does business there. But apparently no indication that any of its activity was in any way related to the claims asserted. So, Bob, after reading the briefing here, I come away with a feeling only, that the Pennsylvania Supreme Court may get affirmed here. But in making that statement, I'm mindful that the person who really established and nurtured these general jurisdiction principles over the year was Justice Ginsburg. She wrote the Goodyear case that I mentioned earlier. She wrote Daimler. Both of those cases figure prominently in the briefing here. And in 2017, she wrote what I think was the last Supreme Court examination of general jurisdiction, general personal jurisdiction principles in the BNSF Railway versus Terrell case. But as we all know, she's no longer there to protect those principles, and how the newer Supreme Court justices will view this issue remains to be seen. Indeed, I was somewhat bemused that the Mallory petitioner's cert petition, that is the plaintiff's petition to the court, began with the following quote from Justice Gorsuch's concurring opinion on specific personal jurisdiction principles in the Ford Motor versus Montana 8th Judicial District Court case last term. And the quote was the following: nearly 80 years removed from international shoe, it seems corporations continue to receive special jurisdictional protections in the name of the Constitution. Less clear is why. So that may be where a lot of the arguments from the petitioner here will be aimed. Bob, with that, I turn it over to you.
Well, John, thank you very much. I'm really pleased to be here with you again this term and looking at these cases, and I thank the Law and Economics Center for inviting me. And what the Mallory case does is, because of the Supreme Court's now going about 15 years interest in personal jurisdiction, which has surprised a lot of us that they have gotten that interested and that continuously interested in examining these kinds of cases, means that they're still struggling, because the fact of the matter is, in my view and a lot of scholars' views, they have made a hash of personal jurisdiction where it's very hard often to figure out what they are talking about or where they're going. And that, of course, is the thrust of that Gorsuch quote that you read to us that was prominently featured in the plaintiff's brief. One of the problems that personal jurisdiction poses is Justice Ginsburg's statement growing out of Goodyear and Daimler that there are just two forms of personal jurisdiction: specific jurisdiction and general jurisdiction. Specific jurisdiction has to do with something that really has occurred within that state. And so therefore, that state does have an overwhelming interest in trying that litigation. It's something where the defendant has put themselves into that position in that state, and not by virtue of being drawn in. General jurisdiction, as you said, is described as the corporation being essentially at home. This is all-purpose jurisdiction, and so whatever the purpose is, they would be subject to the court's jurisdiction. The Ford case just a couple of years ago was a specific jurisdiction case in which Ford basically argued a similar approach to general jurisdiction, that they could be sued at their headquarters where they manufactured the car, maybe even where they sold the car, but not where the accident itself, the collision that injured the people, could occur. And the Supreme Court found that there was such an overwhelming interest in those instances, this was consolidated cases, Montana and Minnesota, that the states really did have the kind of interest that allowed specific jurisdiction to be applied there, and that Ford's activities in those states were sufficient to allow that reach. Noting, for instance, that Ford recalled the cars, and one of them was serviced by a dealership in that state, things like that. So that brings us to Mallory. And Mallory, is being portrayed and was reviewed by the Pennsylvania Supreme Court as a general jurisdiction case. And as John indicated, the Pennsylvania Supreme Court claimed that Daimler radically or dramatically altered the traditional due process analysis for general jurisdiction. The question then becomes, is the court going to change the way that they look at this? And I think that's the only hope that the plaintiffs have. If the court looks at it in a different way, if there's more than just specific and general jurisdiction, and I would submit there is, we know that there is consent jurisdiction. So the parties, while they cannot consent to subject matter jurisdiction, which means give the court power to decide a controversy that it's not otherwise empowered to do, that they can't do that. But they can consent to personal jurisdiction, allowing a court to exercise authority over the person, or in this instance, the corporation. And of course, the Mallory plaintiffs go to great extent that say that this is a consent statute. They also cite to Justice Scalia's decision in Burnham, which is a tag jurisdiction case in which the court upheld as consistent with due process what is called tag jurisdiction. So if you are temporarily within that jurisdiction and served with process at that time, you can be subject to that court's jurisdiction. That, under Justice Scalia's decision, which was a plurality decision, was a sufficient connection, and the service of process is really the exercise of jurisdiction there. So what the plaintiffs are arguing, because the plaintiff who brought this lawsuit worked for the railroad in Pennsylvania, among other places, including Ohio and Virginia, and lived there until he retired. So that his connection to Pennsylvania is what they're basing it on, and that normally is not enough. But the question is, the railroad has almost 2,300 miles of track there, operates 11 railroads and 3 locomotive repair shops. And so the question is, by virtue of this registration statute, did they knowingly consent to jurisdiction? And so that's a question that has been raised by the plaintiffs. There's an interesting amicus brief filed by Professor Stephen Sachs, who is an originalist and who basically says due process has nothing to do with jurisdiction. And so therefore, if you look at originalist approaches to this, that there should be no question, and you should affirm or certainly not set aside the 1917 decision in Pennsylvania Insurance Company versus Gold Issue Mining, because that one affirmed this as a perfectly appropriate jurisdictional statute. When you register, you consent to jurisdiction. But he does raise a separate question, which is also raised by a group of non-originalist civil procedure professors in the amicus brief, and that is whether the arguments that the railroad is making are really dormant Commerce Clause arguments, and that is a better way to look at this question, that there may not be sufficient information developed in the lower courts, and so that it should be remanded for those purposes. Having said that, I would also like to jump in and say something about the Georgia case, and that case, the Cooper Tire case versus Call, which John mentioned. It's being held while the court decides Mallory. And my guess is that whatever happens in Mallory, we will see what's known as a GVR, grant, reverse and remand, grant, vacate and remand, so that the Georgia Supreme Court can look at it again in terms of whatever is decided in the Mallory case. And my guess is that Georgia will retain the same position that it had before, because there's a difference in the facts that I think is significant. And that difference is that the injury occurred in Florida to a Florida resident, but who was in a car owned and driven by a Georgia resident, and that the allegedly defective tire was installed on the car in Georgia. So there are by a Georgia car dealership. So all of these give Georgia a stronger connection to the injury, in some ways in the way that the Ford jurisdiction case came up with, than it may exist in the Pennsylvania case. And for that reason, I think that the Georgia case is a case where a registration statute may indeed work as consent. And I think it's pretty explicit in the statute that by virtue of registering to do business in the state, you are agreeing to it. But as I said, one of the interesting things about this case is not so much the law as it exists, but the direction the law is going to take. If this is a court that cares more about history and originalism, they may move in a wholly different direction and would change the way that they look at the Mallory case. If they also are not anxious to overturn precedent, they have this 1917 precedent hanging over their head too. Now, we've seen that they haven't been very reluctant to overturn precedent, but that is in the service of an originalist approach. So I am really curious to see how they do approach this.
Bob, if I may, I'm sorry.
No, I was going to say, did you have something to reply to any of that?
Bob, I just had a question. So on your last points about the Cooper Tire case, are you suggesting that if remanded after decision, Georgia would be looking at specific jurisdiction considerations? Because the facts you were just putting out there seem to be more on that side of the fence than they would be general jurisdiction.
Well, again, I think this is not specific or general, but more of consent jurisdiction, and since the court has talked about due process as applied to state courts in terms of federalism, whether the state is essentially exercising extraterritorial jurisdiction that really belongs someplace else. And I think one reason that wasn't an issue in Ford, not because of its specific jurisdiction nature, was because of the strong interest in preventing collisions on their roads that these states had. And so I think, again, the activity that took place in Georgia makes it a stronger case than necessarily the activity in Pennsylvania.
May I ask you a quick question, Bob? And that is, are you articulating a kind of consent plus standard here that consent alone is not enough, but consent plus, and we're getting into sort of fact specific cases?
I think that consent can often be enough, but I think it's a totality of the circumstances. And so where the consent is clear, there's no question. And where the consent is maybe more implied, as John suggested, but there is that plus factor, then consent plus may be the right way to go.
Excellent. Anything more on that case, John?
Nothing from me. Thank you.
All right. I think we're going to talk a little bit more about dormant commerce clause, Bob, right?
Exactly. So in some ways, that question that's out there that really wasn't addressed by the parties, but only by the amici, comes to fruit in National Pork Producers Council versus Ross, which will be argued in October. Now, what the dormant commerce clause means is that you look at state laws that have an outsized extraterritorial effect. The dormant commerce clause applies to state regulations that have the practical effect of regulating an industry outside the state, or if the burden on interstate commerce is clearly excessive in comparison to the local values. And that's language that was used in Pike versus Bruce Churching in 1970. But the court has also put some limits on the dormant commerce clause, and we saw that in the South Dakota versus Wayfair case in 2018, where they reversed a prior ruling and held that South Dakota, for instance, could require large out-of-state sellers, like Wayfair in that instance, to collect sales tax for shipments into South Dakota and then remit them, despite the fact that there was a Commerce Clause challenge. So what's going on in this case? California passed a Proposition 12 in 2018. It creates civil and criminal liability for sellers of pork meat in California who knew or should have known that the female pig that gave birth to these pigs comes from a facility where she was not housed with 24 square feet of space and in conditions that allowed her to turn around without touching her enclosure. Now, according to the petitioners, there are no pig farms that comply with that. The typical pens are 2 by 7 feet for animals that weigh 400 to 500 pounds. So they're really packed in, and there was and this was clearly enacted out of humanitarian concerns by a vote of voters. And it's interesting, in 2020, there was a Fourth Circuit case dealing with Smithfield Farms in North Carolina, which is actually owned by a Chinese company. And what Judge Wilkinson of the Fourth Circuit wrote was that it's past time to acknowledge the full harms that these unreformed practices of hog farming are inflicting. He noted that 10% of pigs die in confinement, likely due to complications coming from their overcrowded environment. So these were the kinds of concerns that California had. Now, a second rationale is that the risk of foodborne illness and associated negative fiscal impacts on the state of California also motivated them. I would submit that that's a better rationale for this than the simple humanitarian one that was also articulated. In any way, 99.87% of the pork sold in California comes from outside the state. And California accounts for 13% of US pork consumption. So the effect here is to reduce the effect of California's law is if you want to sell in California, you're going to have to reduce herd sizes. You're going to have to build costly new facilities. These are the arguments that the petitioner is making, and require changes in just about every aspect of caring for these pigs, including the feeding, the breeding, the medical care, and the farm labor. And so they argue that this would raise prices in transactions with no California connection. It will drive smaller sow farms out of business. And the US, again, a brief filed by the Solicitor General, said that these are plausible allegations that should not have been dismissed out of hand. And that's the other aspect of this. We're not deciding right now whether there is a violation of the Dormant Commerce Clause. We're deciding whether it's plausible that one has been alleged and that it ought to go forward past the pleading stage. And so California argues that, the Dormant Commerce Clause doctrine is impossible to apply, that makes little sense. And they cite Justices Thomas and Scalia as saying that it's without basis and open to too much judicial discretion, inconsistency. And instead, if you look at a traditional Commerce Clause jurisprudence, there's no issue with their Proposition 12, which does not control pricing, does not regulate wholly out-of-state transactions. So therefore, they say this is clearly within the police power of the state. They claim that the effects that are asserted by the defendant here are implausible and inconsistent with allegations in their complaint. And even if it does, it has no outsized effect. And so this is the argument that's going to be made. And if I can use a bit of prediction, my guess is that they're going to be allowed to proceed in this case, that the court is going to say that there is enough plausibility to these allegations that it should go forward, and the courts should hear it and make a determination under the Dormant Commerce Clause, including whether the Dormant Commerce Clause really does have any effect here.
Well, Bob, that's a great summary of that case, and I tend to concur in your predictions about the conclusion here.
But you're favoring a plaintiff.
What's that?
But you're favoring a plaintiff.
Well, to be sure. What I found fascinating in reading the briefing in this case is you'd think that if you were getting into a Dormant Commerce Clause issue, it would be filled with mostly legal arguments and I'm not saying there aren't legal arguments here, but I was struck at how emotionally charged these briefs were and how much time was spent putting forward both sides' factual position, which is also interesting because we're talking about dealing with a motion to dismiss that where you're not supposed to be looking and testing the facts. But let me be more specific about that. I mean, on the side of California, the briefs are filled with, very graphic descriptions, which you did justice to, of the circumstances in which the hogs exist in the circumstances. It drew comments from judges along the way about the cruelty of this, which was highlighted in the brief, and some sarcastic reactions along the way to the veterinarian experts who were brought in to say, oh no, this is how you're supposed to do this. And so, you get the impression that the voters in California, and it's an important, and this is a point you made, this was a referendum, this was a ballot issue, but there was great anger that was generated among voters in California in adopting this. And like most referendums in California, it probably wasn't as narrowly drafted as you would if this were coming out of the legislature. So you had that great emotion on the other side. For its part, though, the pork industry, I thought, did this marvelous job of depicting how intrusive this regulation would be. One thing I would add to your description of that is the fact they were looking at this from the perspective of the individual pork producers, those who are growing the hogs. And as you noted, virtually none of this is occurring in California. They talked at length about the legislation specifically authorizing inspectors from California to travel the country to inspect the hog facilities in these other jurisdictions, and noted that if I'm a hog farmer and I decide, okay, well, I don't want to comply with that, so I won't sell in California, I don't have that option because I simply put my hogs into the supply chain and others are in control of where the product is sent. And it notes how diverse that is. And there's no way for the person who has got the biggest compliance obligation, that is the hog farmer, to basically say, okay, I just don't want to comply. They don't really have that option, which seemed to me, when I first started reading, is the obvious thing, we'll just stop selling in California. But it's the end producer that is making the decision of what goes into California. And I suspect at their end, they'll say, well, we didn't know where this came from. So it's on both sides, the facts are extremely important. And when you get finished, you just sense this huge emotion on both sides of the California arguing this is a horrible, cruel practice, unfair to animals. And on the other side, the hog producers basically saying, you're going to put us out of business because we can't really comply with this and can't evade by simply deciding not to sell into the state. I think you make an important point, though, about the fact that this is basically a question of whether this case can go forward, because I was reading this, I'm all these, as you were suggesting, all these questions are going through my mind of where do you draw the lines here between a state reasonably establishing safety type regulations as to what goods and services can be sold in the state by someone residing outside the jurisdiction, in which I don't think there'd be much debate about reasonable regulation in that regard, versus something like this, which has, I think, admittedly very broad circumstances. But I think I agree with you. I'm not sure the court needs to make that decision here if it decides to say, let's let this complaint go forward. It shouldn't be dismissed at the outset. That's also an interesting feature of this that I was intrigued by, having been on the other side of many decisions saying, no, it's too early, you've got to let this, you need a final decision on this before we review. But here we have the Supreme Court getting getting into this at the motion to dismiss stage, which is an interesting development in and of itself.
Bob, you're muted.
I agree. It's very interesting because this, there's always an opportunity to say, yes, we're going to decide what the law is underlying this. And as a result, as a matter of law, there's enough here to go forward with, or there's not enough here to go forward with. My guess is that the court doesn't really want to take that up in the context of this case. There are so many other cases where state regulations have extraterritorial effect. And we're going to see more of that simply because there are multi-state operations that advertise on the web, and there's regulations that control what you can do in one state that you cannot do in another, and things like that are going to be knotty problems for the court. And I think that the Dormant Commerce Clause does come into that, and the question then becomes, how do you allow a state to regulate where they've experienced a real problem with a particular industry, but another state has not had that problem and chooses not to regulate?
So I do want to get on to the next case, but just a quick question to each of you on this one. If it is allowed to go forward, of course, that may be inviting the filing of a number of different cases from which the court could later choose to address the Dormant Commerce Clause. In other words, many people who've been hesitant to file suits under the Dormant Commerce Clause may very well think that they have a credible claim after the case, if it is indeed allowed to go forward. Do you agree?
I do.
Yes. I agree as well.
John, you're going to take us through to another case, but before we do that, I want to remind the audience that there is a Q&A box at the bottom of the screen. If you have questions that you'd like to be considered for the panel at the end, please do use that Q&A box. John, take us away.
Okay. Well, I'll start by noting that the next case we're discussing, I would say, is not a case of modest ambitions. And I say that because at the outset, the cert petition flatly states that the petitioner, and I'm quoting now, challenges the very existence of the Federal Trade Commission, an independent agency created by Congress, as unconstitutional. Now, when you get into the briefing, it becomes apparent that I think the real threshold issue here, when you look at it, is when may a petitioner assert and pursue such a challenge, but the ultimate objective here is certainly in the mix in the briefing before the court. I think, as you all know, the Federal Trade Commission Act, the FTC Act, declares unlawful all unfair methods of competition in or affecting commerce, and it established the Federal Trade Commission as an independent agency to enforce that mandate. Now, if the FTC spots a situation in which prohibitive acts it thinks may be occurring, there is what some people describe as a somewhat mysterious process in which they confer with the Department of Justice to decide which will take jurisdiction over the matter, which will pursue the issue. And the issue in this case is that if a case goes on the Department of Justice track, if DOJ takes responsibility for the antitrust division there, any enforcement activity incurs in a federal district court. The determinations are made by an independent fact finder, that is an Article III judge, with no connection to DOJ. However, if the matter stays at the FTC, if the FTC decides it's going to pursue the matter, it is on what the briefing calls an administrative enforcement track. And under that approach, initially the FTC staff will investigate and present, if it concludes it's warranted, a complaint to an FTC administrative law judge with evidence from which to make factual findings and reach conclusions of law. So in other words, instead of going to court, you're going before an administrative law judge within the agency. And the petitioner notes that these ALJs are insulated from presidential control by what it calls 2 levels of for-cause removal protections. The ALJ issue decisions on, it will issue under the FTC process a decision on any contested issues of law and fact, and an ALJ can order a remedy. Then those decisions by an ALJ can be appealed to the 5-member commission itself. Then, if the commission issues a cease and desist order, the target company or defendant in the case can then obtain appellate review from a federal court of appeals. And the statute says, and this is a critical piece, that the Court of Appeals has exclusive jurisdiction to set aside such orders. So the petitioner sets up this, what it portrays as a very simple path to get into federal appellate court to review an enforcement effort by the Department of Justice versus a long multi-step process at the Federal Trade Commission, which they stress at every step of the way involves FTC personnel. They also make the point that they are unaware of any instance in which an ALJ has ever disagreed with staff in this circumstance. I'm not sure that's right. I think I read about one several weeks ago, but in any event, it's basically an argument that you basically have a hometown process, as we would say on the litigation side. Let's get to the case. The petitioner in this case is an entity called Axon Enterprise, and they make body cameras and digital evidence management systems for law enforcement. Axon acquired and what it describes as an essentially insolvent competitor called VIEW, and the FTC soon after that acquisition started expressing competition concerns. After about 18 months of investigation, Axon offered to walk away from the deal. We're tired of the investigation, and said, look, we'll divest what we acquired here, the VIEW assets, and we'll infuse that entity with capital so it can go off and continue to exist essentially as a competitor. The FTC declined that offer, and again, according to the petitioner's briefing, insisted that Axon, in essence, turn this VIEW entity into a clone of itself. And that term was quoted from some of the FTC correspondence, using the Axon intellectual property and providing even more capital than than Axon had originally proposed. So according to their characterization, the FTC was demanding that, having acquired this entity that apparently was destined to go out of business, it was now required to build with its own intellectual property and capital an equal competitor. I'm sure there's some debate about that, but that's how it was characterized, that the FTC wanted a lot more to end the controversy than Axon was willing to provide. So at that point, Axon threw up its hands and filed a lawsuit against the FTC in federal district court. And it was that lawsuit challenged the manner in which FTC ALJs are appointed, challenged their dual layer protections from removal, challenged the combination of prosecutorial and adjudicatory functions in the single agency, that is the internal bias that I mentioned earlier, and what it referred to as the black box manner in which DOJ and FTC enforcement authority is determined in a particular case. That is, which agency would undertake a particular investigation. So this was an all-out assault on the FTC in this separate lawsuit filed in federal district court. The FTC immediately then internally filed a complaint, again, in its internal process, that challenged the Axon acquisition. So they put the issue at that point before one of the agency's administrative law judges. So the federal district court dismissed the Axon action, holding that the FTC Act's provisions saying that cease and desist orders can be challenged only in courts of appeal controlled. So the district court said, look, this is all part of this enforcement action that's at a nascent stage in the agency. And so you have one path to judicial review of this, and this is through the Court of Appeals process that's specified in the FTC Act. But you've got to wait till you get to the end of that process and actually get a cease and desist order from the commission itself. It rejected Axon's arguments that the FTC statute is silent about where basic challenges to the agency structure should be heard. And Axon argued that since the statute is silent on that score, jurisdiction should reside in the district court. In a split decision, the Ninth Circuit affirmed the dismissal. They articulated a three-part test, or I shouldn't say articulated, but they noted a three-part test on this issue, which was, can the petitioner obtain judicial review through the statutory scheme, whether the claim is wholly collateral to the statutory scheme, and whether the claim is outside the agency's expertise. In the end, the majority, having set forth that three-part test, sort of said, well, the main thing here is, can you get appellate review? And you can get adequate review at the end of the process. And that's enough. The dissenting judge simply concluded that absent legislative language to the contrary, a challenge to an agency's basic structure, procedures, or existence, rather than adjudication of the merits of an enforcement matter, may be heard by a district court. There's a lot of qualification in the dissenting opinion, but basically was much more favorable to Axon. It's likely, in my view, that the case will turn on how the Supreme Court views this case through the prism of its 2010 decision in the Free Enterprise Fund case. In that case, as some of you may recall, an accounting firm argued that the existence of the Public Company Accounting Oversight Board, which was structured through the Securities and Exchange Commission, violated the appointment clause and separation of powers. In that case, the court concluded that such a general challenge to the board was distinct from any particular orders or rules from which appellate review might be sought. And in that case said the petitioner should not have to wait, that is, the challenger should not have to wait for adverse action to make the fundamental challenge or violate the law to invite action. And there's a lot of discussion of that opinion, do you have to go violate the law or do something to create an issue that you could then take up on appeal? Axon argues that's the situation it's in here. However, the SG, on behalf of the FTC, argued the situation here is distinguishable because Axon is the target of an FTC enforcement action, which will provide a path to appellate review. In short, it tries to distinguish the SEC case by saying, yeah, but here you've got an enforcement action in progress, which clearly precipitated what Axon did. So this case is different. And Axon, of course, urges that it should not have to endure the FTC proceeding before being allowed to raise the question whether the FTC is constitutionally constituted in the first place. I think I have mixed feelings on where this will come out, although the fact that the court granted review in this case suggests to me that they may let Axon go forward here, but not and there are some good points by the SG in distinguishing this case from the Free Enterprise Fund case. But Bob would be interested to hear what your take is on where this might be headed.
Thanks, John. And Bob, before you go, I just want to let you know we have about 6 minutes left, so keep that in mind.
I'm going to be quick so that we can get to some questions. And let me just say that John gave a very thorough rendition of what's at issue in this case. This is a company that's looking to avoid what it claims will be years of proceedings and investigations by challenging directly, basically, the structure and authority of independent agencies. Now, let's make sure that we all understand that the government has a lot of independent agencies. The CIA is an independent agency. The Postal Service is an independent agency. The Maritime Commission. So we have quite a few that have grown over the years. And this is a product of the New Deal. So in some senses, this is an attack on at least part of the New Deal. But John is right. This is a question of whether or not there is jurisdiction in a district court to essentially look at that question of constitutionality and structure rather than wait until there is a decision by an independent agency and attack it in a federal court of appeals. And so that is really the question that's going to be answered by this decision. And I agree with John that by taking it, they've indicated that there is a tendency, Justice Brennan used to say, well, it only takes 4 votes to grant cert, but it takes 5 to know which way that grant will go. And I always wait for 5. So I suspect that that lesson has been learned by the court. Having said that, there is some indication from the Seal of Law case that Chief Justice Roberts wrote that there are some issues with independent agencies, at least when there is a single head who cannot be removed by the president. There are First Amendment cases like the Susan B. Anthony list case, which isn't mentioned in the briefing, that talks about having the sword of Damocles hanging over your head for many years. And so therefore you should be able to go in and seek a declaratory judgment. And so all of these, I think, are in play here.
Anything more on that, John?
Nothing more for me on that one.
Great. Well, we have one question in the queue, and then I have a couple questions if there are no others from the audience. But if the audience would like to post one more in the queue, we can probably get to it. But the one in the queue is, what do you make of the fact that the pork industry's own economists filed an amicus brief on behalf of neither party, saying they don't like this policy choice, but the MPC's arguments about the impact on the industry are implausible, as found by the district court and affirmed by the circuit?
Well, let me start and simply say that this is the kind of amicus brief that the court will take seriously. It's credible for that reason, and it's something that they'll look at somewhat seriously. I don't know how much it's going to affect the ultimate outcome of this, but I suspect that whatever opinion is issued will take note of these statements.
Yeah, and I'd go back to the point that I think both of us made earlier, that this being arising on a motion to dismiss. I don't know how far the court's going to get into facts. Certainly the impacts are alleged here. And so the question is, should there be further development of these facts? So Bob is right. The brief may be taken seriously considering its source. On the other hand, this is to be discussed later if the court decides to reinstate the complaint.
And John, you made a point there about the allegations. This case is not churning on an Iqbal kind of plausibility analysis, correct? It's whether or not it can survive the standards for a motion to dismiss.
Correct.
All right, so we have just a couple minutes left. We do have one more question in the queue. Do you foresee big precedent that this court might overturn this term? And this is from John Turris.
I'm not sure yet. We're certain that there's a big precedent that will be overturned. There's a lot of potential here. And talking about the personal jurisdiction case, Mallory, there is an opportunity for the court to essentially strike out in a new direction on personal jurisdiction and no longer abide by this dichotomy involving specific and general.
That based on the cases Bob and I were focusing on, I think that's the one where you might see a shift. I think Bob and I may disagree if that's going to happen, but that seems to be among those that we were looking at in the civil justice arena, a possible case.
Excellent. Well, we are just about at the hour, so I want to ask a final question of each of you, if you can take just 60 seconds to answer it, and that is, are there any petitions that are pending that you're watching and that you think this audience would be particularly interested in, or issues that you are watching that you think the court might take up somewhere along the way this term? Bob, why don't we start with you?
Well, I'd be remiss if I didn't say that two cases that I am involved in are ones that I'm watching closely. One is a commercial speech case in which this is involving attorney advertising, but goes to really the standards that are used for commercial speech cases. It arises out of West Virginia and involves a statute that prohibits lawyers advertising for drug and medical devices from using the word recall accurately as defined by federal law, and also attaching to it 30 seconds worth of disclaimers, which basically means you cannot run a 30-second radio or television ad. The second case is a personal jurisdiction case. It involves a collision of a US Navy destroyer with a Japanese tanker in the Sea of Japan. And the question is whether the US Navy personnel who were killed or injured can bring an action in the United States.
Excellent. John.
Just quickly, I think that without focusing on a particular case, I think we're going to continue to see petitions coming in, some of which may interest the court on the personal jurisdiction issue that we talked about previously. As Bob said, I think in the lower courts, there continues to be some uncertainty, some of it created by some of the recent Supreme Court precedents in that area. And although I think there may be a hesitancy on the part of the court to go there because of the recent change in the rule of evidence on this issue, I still think we're seeing this flow of Daubert issues continuing to come before the court. And I don't have a particular case in mind, but I do think, just given the repeated, the drumbeat of a desire for attention to that issue, the court may take one of these days, although the recent change in the federal rule of evidence on the admissibility of expert evidence may cause them to pause to see if that addresses some of the concerns that are being raised in these petitions.
Well, thank you very much to John Beisner of Skadden and Robert Peck of the Center for Constitutional Litigation. We are delighted that you were able to join us today. And thank you to all of you who have been watching our Supreme Court Civil Justice preview of the upcoming Supreme Court term. This has been a webinar of the Law and Economics Center at George Mason University's Antonin Scalia Law School. We hope that you will join us for future webinars. Keep your eye on your email for announcements about those, as well as looking at masonlec.org. That's masonlec.org. And if you'd like to support programs like this, there's also an opportunity to do that there. In addition, I recommend that you look at our events and go to our past events tab. Look at the Civil Justice Academy listing of events, where many of these past webinars have indeed been recorded and are available for viewing on demand. Thank you again to all of you for joining us. Have a wonderful Constitution Day tomorrow, and enjoy the rest of your weekend.